notice with just another final chance. I'm giving you another opportunity to remedy. If they've not fully responded to your thing, now with the Solicitors Regulation Authority,
may I just ask,
yeah,
for each of these, do you include the remedy in every one?
the remedies in your caution notice, if they do respond partially, okay, then you may have to modify your remedy, and so you'll change that in your next notice, and same thing in the final notice.
And can the remedy change depending on the response?
Correct, correct, yeah.
I'm so sorry because I came late. So
Don't be
you
sorry.
said this. I just wanted to
Glad
ask:
you
is this when you're on the attack rather than like a conditional acceptance? Like,
Yeah, okay, conditional acceptance. Okay, conditional acceptance, I'm subservient. I'm admitting there's something there. I conditionally accept your whatever. I'm saying, listen, I don't accept at all. I stand on my right. I need you to prove.
okay.
Okay, so again, it's swapping, but yes, a conditional acceptance basically is the same sort of thing. But from the viewpoint of self-empowering, the conditional acceptance is actually giving them some, what you're saying is, oh, maybe you're right. I'm just simply saying, prove you're right. Okay, so it's about empowering yourself and not being subject to it. Okay, so reasonable time. Okay, honour is about reasonableness. Oh, sorry, yeah, so the SRA, okay, basically, I found out this thing because I used to
What's
use
an SRA?
a Solicitors Regulation Authority. Okay, so I used to use, please provide a full and accurate statement, sort of thing. Okay, or your response full and accurate. However, until I started using the word and complete, okay, when I started adding and complete, things changed. Okay, and complete means you cannot omit. So what they were doing, giving full and accurate, okay, of selective stuff, but not the whole stuff. Okay? And the SRA, actually, I got an admission from them, they lied to me, using that. And so, again, this is stuff that we're learning as we're moving on, okay? You know, until we've experienced it. Remember yesterday I was saying I used to say oaths and affirmations until some policeman said, no, I'm attested. Okay? So it's about applying as we just adapt it as we move forward. So it's all about reasonableness. So I was saying that I put the 4 solicitors and the Queen's Counsel on notice. Basically, I finished going through the judgment a week before it was due to be handed down. So is it reasonable for me to use a 7-day or a 14-day or a 28-day period? No. So the first notice I gave them 24 hours, second notice I gave them 24 hours, third notice I gave them 24 hours. Okay? And with Calvin we did the, to try and get an appeal, we did the same thing. Okay?
Give them an hour notice.
Yeah, and basically reasonable comes down to what's reasonable in the circumstances. I started testing this stuff in Coburn Misfits with the anti-fracking protest in 2017. So what happens? The police come up and say, in accordance with the Trade Union Act, you've got to move. And then they come back a few minutes later and say, I told you, you've got to move. And say, if you don't move, I'm going to move you. So, are you sure you don't want to move? Because now I'm going to move you. So, I've given you the chance, I've made my claim, Trade Unions Act, I've given you a reasonable amount of time because the convoy is coming in 15 minutes, you know, so, and I need you moved out of the way 5 minutes before they come. So, everything is the same, everything works with this. So basically, Trade Unions Act, I don't see my name in being enacted by the Queen and the Lord Spiritual, Lord's Temple and the Commons. Do you see your name, Mr. Policeman, on here, or my name? What makes you think this applies to me? But on the first page then, what trade union do you believe I'm a member of? They can't answer that. Okay? So the first night they went back to their gold command and said, oh, there's this idiot called Mark there, you know, and he's pointed this out. So the next day they came with obstruction of the highway. So it was a small lane, so when they came up to me, it's like, I don't see any traffic there, do you? No. Don't see any traffic there, do you? No. So therefore, who am I obstructing? But those two police vans that are parked there and forcing cars off the road on the verge, they're obstructing, why don't you go and get them? And he went and got them moved. Okay. And then the next day it was for my health and safety, and I said, look, I'm over 18, it's fine, but just in case you see that I've missed something, shout. Okay? It didn't stop them from physically retaining me, but you can see the process at work. They left me alone, okay? They still put police with Kate and me and the dogs, you know, to make sure we don't, you know, go and jump on trucks.
Sorry, I missed the thread. Who is there?
The police.
So the police left. The police are the ones that come up to move you.
The police come up and say, in accordance with the Trade Unions Act, in accordance with the obstruction of the highways for your health and safety, because they knew there was nothing they could do. But they'd leave me alone. So on the day when I rebutted their claim of the Trade Unions Act, then they still carried on bullying and pushing it in, you know, everybody else. Why? Because they didn't rebut the claim. However, because I rebutted the claim, okay, they should have stopped implementing that because they knew that they had no lawful excuse.
That just proves they're bullying, really, doesn't
Correct.
it? Because they
Yeah,
know
yeah.
they're not actioning onto you, but they were wrong, but they'll do it to somebody else because they're
Correct.
weak.
And this is
That is
the way they work, okay? Just hang on a second. Okay, and so the point is, if you don't individually stand on your rights, okay, what happened there was they are knowingly harming others. Therefore, if I don't do anything about that, I am breaching the peace. So we need to stop turning a blind eye and start standing up for other people. Okay, and that should really stop really quickly. Sorry, yeah.
Just, I know that you did a very good rebuttal of it, but how is the Trade Union Act even relevant?
Don't ask me, ask the police. Yeah, I can't, I absolutely agree with you. Okay, but basically, they literally just pick anything out of the sky. Honestly, it's absolutely ridiculous. Okay, you know, they know they've got no basis. For remedy, I asked for various things. Now, I got hold of the chief thug. There were something like 75 police there. I got hold of the chief thug and gave him notice. And part of the notice is you actually need to ensure that the recipient understands it. So I was going through, and he said, "Oh, this is going to take a long time." I said, "Yeah." And
Is this
so,
verbally or in writing?
no, I gave him a written notice.
Yeah.
Okay, and so with that, basically we agreed, okay, if he's got work to do, we'll intervene and go and have a coffee while he's busy or whatever. So he gets a call on his radio and blah, 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 and turns around to me and says, look, we've got to intervene here now, I've got work to do. We've got a convoy coming in 15 minutes. We've got a convoy coming in 15 minutes, who are you working for? Okay? And honestly, they'll just totally mess themselves up. And it came then to the point where he said to me, you need to move over there. Okay, and they had their little fence and they were trying to herd everybody behind the fence. I said, no, I've given you an undertaking, I'm not going to jump on the truck and I'm not going to interfere with the truck. If a truck needs the swing room, I'll move over there. And the guy said, no, you'll move over there. I said, no. And he said, you'll move over there. I said, look, both of us know you've got no lawful authority to lay a finger on me. And he just walked away. Okay? So those who stand on their rights harm no one. Those who don't have none. It's so important. But to do that, you need to know yourself. If you don't know yourself and your power and what you are, okay, forget it, it doesn't work. But that's how they work. Somebody points out that they're wrong. And literally, they turn a blind eye and ignore that, and will just carry on with everybody else. So unless we start standing up for others, okay, nothing's going to change. The wolf pack, you know, they've got the strong wolves in the front and the back.
Yeah,
Okay, and they herd the middle. They look after the weakest link.
that's what foxes do too.
Loads of, that's the way nature works, except for humanity. We just don't do this. So now, with the notices, basically what we're doing is stopping them turning a blind eye. That's what we're doing. Okay. So it's very powerful. It's used all the time by everybody. A bill is a claim. That's what the word used to mean, a claim. So if you're having renovations in your house and the guy sends you a bill, what are you going to do? You're going to check if the bill is right. Have I agreed to this or have I not? Okay, you negotiate, you settle the bill, how much is due, and then you make payment to settle the bill. Okay? So the council's sending you a bill, making a claim against you, and we're just asking, where's this claim come from? What's the basis of it? Okay, where's the obligation? Where's the joinder? Where have I agreed to this? Because nobody has the right to impose their will on anybody else. So that's the overall structure of notices and what and how you can use it. So with the notices, I give a brief description of what it is, and basically I'm trying to standardize it, that there are only certain sections that we need to change. So I'm trying to reinforce this thing. Everything's about a breach of peace. Okay? Because that is the simplicity of the truth. So a breach of peace dash fraud against the mind. You can download this, so don't worry about writing it down. Fraud against the mind, crime against a person, or trespass upon property. That covers every wrong. Okay. Notice to print. Then also we say you must cease. It's a cease and desist. I'll put you with the facts, and you must desist until this dispute is settled. Then it's got notice to principal is notice to agent. Notice to agent is notice to principal. This is brilliant. Okay. So, like I said yesterday, down Land's End, the policeman says, you more than 5 miles from your home is not against the COVID regulations. Okay? Sorry, can you please prove your claim? Does COVID exist? Show me your evidence. Is it transmissible? Does it cause unique harm? So that there is a notice. Prove your claim. I.e., cease your behaviour, stop any COVID regulations. And desist until you've provided me with the evidence. That then goes all the way up to Queenie, or Kingy now, up to the top of the crown, and it goes all the way down. So notice to principal, I've put you with a notice, you must notify your principal must notify their principal. So it goes all the way up the chain, and each of you must notify your agents.
But they don't do it.
Okay?
Can we enforce that, Mark?
Yeah.
Because I've done this, but written to the CEO and he's not
Yeah.
told the people below. Yeah.
You'll see how I'm trying to change it. So here up in Land's End's another policeman. Within a day or two, that policeman on the opposite side of the country should know, oh, hang on, there's this claim from government of COVID regulations, and somebody's disputed it down in Land's End, and until that dispute is settled, we can't enforce it. So why do we need arrests? Why do we need protests? Why do we need any of this nonsense? That's how the system should work. It's designed to do that, but it's not. Okay? Just like we're pointing out. So that's what notice to principal is notice to agent. Notice to agent is notice to principal. To do this, though, we need to notice a legal fiction. Okay? And so we use the legal fiction to our advantage. And the other thing is, with the anti-fracking protests, yeah?
One of the things that we do use the legal fiction, but we also use the actual man.
We'll get
by
onto
saying,
that. We'll get onto that.
all right.
Yeah. Okay. In the anti-fracking protest, they had a problem because guess what? Frackers just pitched their tents in fields and stuff like that, and they didn't know their names and they couldn't serve them court papers. So, Ineos, being a very rich company, at the time he was the richest guy in the country, even though he lived in Switzerland, he went and wanted to bring an injunction against frackers. And basically what they were trying to do is, if here's the road, okay, and then the hedge, they were trying to get people off the road, off the hedge, with their signs and all of that stuff and their tents, and put them behind the hedge in the field where they were going to do stuff, and they were going to make lovely pig pens for everybody, and you could go inside these pig pens and hold up your posters to the people doing the work of it. Okay? And so they thought they had a problem, how do we serve these people? And so they went through and identified the people and found their Facebook accounts and got hold of their email addresses and stuff like that. And at the time, email service was not deemed acceptable. But Ineos's lawyers went and spoke to Master Marsh and said, hey, listen, how are we going to overcome this problem? You know, these guys are cutting into our revenue because guess what? Ineos has human rights. It has the right to do business. Human rights for bloody fiction out of your head. So they have a deal. What you do is, you send an email to their known email address, and you send it to two dummy addresses. So their actual address, and witness 1 and witness 2, two dummy email addresses. So when you send the email, you include 3 email addresses, and if that person who you're trying to serve says, I never got it, then they just say to this guy, did you get an email with that guy's address on? Yeah, can you sign the certificate? Did you get an email with the guy's address on? Sign the certificate. So the certificates then are proof of service to the person. So it's lovely, because now we can use that as a precedence from the High Court to serve anybody with email. So again, this is why I keep saying there's always a silver lining. Okay, there's always a mirror. They will always hang themselves. So now we can use this as a precedent to serve.
So can I just clarify?
Yeah.
So you can send an email
Yeah.
to customer services.
Yeah.
In the subject line you can put for the attention of the CEO.
Yeah.
And then put notice to agent is notice to principal.
Yeah,
and then-
notice to principals, notice to agent,
Job
notice
done.
to agent,
Thank you.
notice to principal. And therefore, everybody should be aware there's a dispute about this thing, and we must cease and desist until this dispute is settled. But this is how simple it should all be. Okay? So, now, basically, just get 2 of your friends, like-minded people. More and more people are now learning about this to become witnesses. Another way you can do it is, if this is at, you know, abc.com, okay, what you do is you make POD, proof of delivery, at abc.com, and proof of delivery at abc.com, and they'll bounce back to you saying undeliverable, but you'll have undeliverable with 3 email addresses on. Okay?
So although
So you-
those 2 are undeliverable, the first one will...
The first
would
one
have
is
got through.
deliverable.
Right, I
Yeah.
see,
Yeah.
okay.
I like it.
Okay. So these are things that we can use to enforce it. And the response you'll get is, this is not legal notice. You know, that's the general response. You know, this has got no standing and all of this sort of nonsense. I don't really care what's your opinion. Okay? That's the answer to that. Take it as you want. I'll put you with the knowledge. Okay. The courts look at 2 things. The first thing is the facts. Okay? Actus reus. And the second thing is the state of the mind. So, you follow your belief, I put you with the facts and ask you for remedy. You've ignored me and continued. So, well done. What you've done is, here you had a chance to say, honest mistake, I'm sorry. But you've ignored me, and therefore now you've acted negligently. Okay? And if you ignore me again, now you're acting grossly negligent. Okay? So what we've done is, we've met the two criteria we need to prove in court. The facts are established by two witnesses. The first witness puts you into the state of mind of negligence, and the second witness, because you continued, you're coming in grossly negligent, i.e. with a guilty mind. Therefore, we've got the evidence that we need for the elements that we are required to prove in court. It's an incredibly powerful thing, and it's used all over. If you don't respond, you've dishonored me, you've trespassed me, I then take you for public dispute resolution. If I don't engage in public dispute resolution, I end up with a default judgment against me. If you don't engage, you will end up with a default judgment, and then you get the bailiffs at the door and all of that, and then you've got to try and clean up the crap to get back there. So engage early.
What does
Don't
public,
ignore.
what is public dispute resolution
The courts.
involve?
At
And
the
how do you-
moment, it's
And
Her
how do you get it
Majesty's
into
Courts of
courts
Prime
when
Ministers.
they're demanding payment fee?
Sorry?
How do you get it into a court when they're demanding fees?
Yeah, we'll talk more about this when we talk about the court auditors.
Brilliant.
Okay, but yeah. Okay, so if you do your paperwork right, you've got all the evidence you need to prove a guilty mind and the facts. So people ask, well, what do we do with these notices? Once we've done this, nothing happens. This is where we need to start now finding ways of enforcing it. Okay? Now in the courts, how does this get enforced, or how can it be used? So I told you guys yesterday I lost 2 cases, it cost me 80 grand. But I didn't know what I know now. I went back and reread the judgment, and she said, your notices are not relevant to the hearing, however, to the costs.
Say that again?
The notices aren't relevant to the hearing, the outcome of her judgment. Okay, because I said, I flipping well said all of this and we shouldn't even be in court. They should have answered these questions before. And she said, okay, I've ruled against you, you were wrong, but the process you went through, your pre-action protocol, is relevant to the cost award, because costs are subjective to the judge. So if I've done everything humanly possible to attempt to resolve the matter in private, okay, and I've been forced to go to court to try and get the answers, I've done what I can, and they themselves have created their own costs because they've dishonored me. And therefore, even if I lose the case, I cannot be asked to pay their costs. Okay? So it's important we get the evidence, because worst case, if we don't get the answers and end up in court, we can argue they forced the matter into court, they've created their own costs, and therefore, sorry, you can't talk to me and get any costs from me. Yeah?
Where was the 40 grand from them? Was that a different case?
No, well, there were 2 applications which they won. I just didn't know how to, I was learning in the courts.
So that was a different one?
Yeah, no, this was the case I was talking about yesterday for the flat in Leeds.
Yeah.
But at the time, again, I didn't realise the actual power of this, and she actually mentioned it in her judgment. But at the time, it didn't click.
So was she wrong then, to say the news?
No, basically, what she was saying is, and this is why I like written judgments, okay? Because it's rational. What she was saying is, hey, listen, you lost this part with the facts and this stuff, okay? They were right, and so therefore, case thrown out. But because you did this, their costs were 40 grand, okay, is what they put in. in the cost award, I should have been arguing, I had no idea what was going on at the time, or very little. I should have been saying, yeah, it might have cost you 40 grand, my friend. But because you did not attempt to settle this reasonably in private, I'm paying you 0 because
Oh, right.
you forced me to court, take this case to court. So it's your own fault that you created these expenses.
So how is the notices not, with the stuff, the questions you'd asked, not relevant to the hearing?
Yeah, no, they were. I mean, the thing is, I was just naive and didn't really know what I was doing, and you know, I'm a bit of a cowboy sort of thing. Just go out and try it. It's wrong. 13 directors can't steal my money. You know, somehow I must be able to explain it. It's simple. You know, everybody knows it's wrong. But the problem is with their nonsense in the court, they actually lied, and I didn't. You know, I just wasn't experienced. It's part of the learning process. It's the way it happens. We've got to learn from our lessons. Okay, so hopefully you can see the way notices work, what's the substance behind it. So when they turn around and say, oh, it's of no legal effect, and they'll always, you know, solicitors will come back, oh, we don't recognise it's not a legal notice. I don't really give a shit what you believe. So long as I know what I'm doing is right, do it. It's about substance, because just like that, in the court, my costs, if I've in substance done the right thing, I actually am protecting myself against potential costs. So, council tax, I send the notices, and that means if they've not answered the questions or not attempted to resolve it, we're now arguing, well, you can't charge costs against me. So basically, going to the theatre of the courts should become free.
At what point was your opportunity to defend yourself against having those costs?
Basically, everything in the courts actually comes down to try and get the disputing parties to reach some sort of agreement, so that the courts don't want to make decisions. They always want consent orders where possible. And if you guys can't consent, they want as little bit as possible to argue about. So basically, they put in a summary of costs at the hearing, you know, what it's cost them to date, and basically say, okay, you lost, therefore sort out with them the costs. If you guys can't sort it out, then we need a hearing for costs. So the one lot wanted 50 grand, and they just slapped on extra, when they did the detailed assessment, they slapped on like an extra 10 or 12 grand. I said, bugger off, what the hell is this? Where does this come from? I'm not paying you, and I only paid them the 40 grand, and that's it.
Yeah, my experience has been that basically people do that in court, is that they thumbsuck costs, and the judge doesn't, or whoever's making the decision, doesn't actually scrutinise those costs.
Correct, because the first stage is, okay, you've claimed 40 grand of costs from me, okay, go and sort it out. And if you guys can't sort it out, then you come back to us and we'll do a hearing for costs.
Okay.
Okay, so just very quickly, I've tried to make a standard format for the notices. It starts off the date, then location of the incidents, what gave wrong, sorry?
So I'm just clarifying, the notices are not in here, did you say?
No,
There's
no,
no written copy?
No, basically the notices are going through the evolutionary process to try and standardise and simplify as far as possible. And so the second point then is the location. Where did whatever happen which gave rise to this? So if somebody sent me a bill, it's through correspondence that this matter arose. Then the statement is, in my own right, Mark Horn of 6 Million Road, granted my mind by creation and sole beneficiary of my body, to explore this reality as dictated by my conscience, which distinguishes right from wrong, provided I knowingly do no other harm. I require email service, so I'm telling them how to respond to this notice and how I want to be served. So send me an email, okay, to my email address and to my witnesses' email addresses.
So you can, if they don't respond to you in the way you require, is that not, that's not, right, okay, yeah, thanks.
One of the solicitors I'm dealing with has an email address, but he specifically says
Correct.
he does not accept service via email.
Correct, correct. We've got to specifically state, no, I do not have, I'm not accepting email service. Okay. And
So if he's not accepting it, and I'm saying, let's say I bring a brand new claim, and I'm saying I
if you're saying you must send me by email, this is how I want to be served.
Yeah.
Equally, he's saying you can't serve me by email, I want it on paper.
So he can send me an email, but I must write to him.
Yeah, yeah.
So where councils put that on the bottom then, that's, we have to do it by post, if they say they
If
don't.
they say they want post, then we do by
It
post.
says they don't accept it by email, so then you have to do it by post.
Yeah.
Yeah, okay.
Okay? Then the next point is references to case law or legislation contained herein are based upon my belief that they follow the rules of equity and hence are rebuttable presumptions, which I welcome in my research for truth as to lies to go against the mind. So what I'm saying is, this is my belief, please go ahead and rebut it. Next one is notice.
Sorry, please go ahead and rebut it, but is that not rebut it in substance? Because they can just rebut it by saying, well, we rebut it.
No, a rebuttal is counter evidence which cuts out and sets a new higher truth.
Thank you.
The next one, notice of facts and judicial notice. Those served must take notice, and the courts, should this matter not be settled in private, must take judicial notice of all the rules of equity, rules of common law, and legislation referred to herein. So what we're saying here is, these are accepted by court as fact. Okay, this is it. I herewith serve you by email this notice in accordance with civil procedure rules, pre-action conduct and protocols, and should we not be able to settle this matter in private, what I'm saying is, look, I'm following the protocol, but if we can't settle in private and we go to court, this is my pre-action protocol. Due to the urgency of the matter with the judgment listed, okay, so this notice that I'm reading is basically the one that for the four solicitors and the QC. Due to the urgency of the matter with the judgment listed for handing down the 13th of September, this is an attempt to prevent any breaches of peace as opposed to using the pre-action protocol for professional negligence after the incident. So what I'm saying here is, because they'll automatically respond, oh well, I'm not your solicitor and you can't make a professional negligence claim against me. I'm saying, hey listen, we're not talking about professional negligence after the fact. I'm trying to preempt and avoid an injustice. Matthew Weber, Karen Coburn, James Vance, here is Carl Mifflin. Failing to immediately cease and desist your believed right until this dispute is settled creates a breach of my peace. My reasons to believe are based on your supporting evidence which makes your claims irrational, hence, and or your suggestions or actions appear unlawful. They just wrote back and said, oh, we don't believe we're under these obligations. As a claimant, you must prove your actions are lawful, as I'm innocent until proven guilty. If you do not desist your believed right, you are knowingly breaching the people's peace by failing to resolve this dispute, and in particular my peace, which is a trespass and the source of all your liability. So my supporting evidence then, my reason for breaching the peace, for sending them the notice, and the equitable basis of my believed rights. So this is the foundation, my standing as a king, which gives me authority to bring this claim against you